Good morning, Kelly Blatnik with Blatnik Law here to discuss the administrative law orders that have been issued by Clark County since the beginning of 2020. Since the beginning of 2020, Clark County District Court has issued 18 administrative law orders that vary or alter the protocols and procedures for Clark County District Courts and specialty courts. On March 13th, 2020, the first administrative law order for this year was issued. It is order number 20-01 that stated all non-essential hearings must be done via telephone or video, decided on the pleadings, or rescheduled, and that only essential cases were to move forward. On March 16th, 2020, Administrative Law Order 20-2 stated that there will be no in-person meetings to discuss court business. On March 16, 2020, Administrative Law Order 20-03 stated that the Family Law Self-Help Center, Family Mediation Center, Donna's House, and Special Advocate Program are closed for in-person assistance but can still move forward via alternative means. On March 17, 2020, Administrative Law Order 20-04 closed the traffic counter and stated that traffic matters are to be handled via alternative means. On March 18, 2020, Administrative Law Order 20-05 stated that alternative dispute resolution matters are to be decided on the pleadings or via a hearing based upon alternative means, and that short trials were suspended for 30 days. On March 18, 2020, an additional Administrative Law Order 20-06 regarding criminal matters stated that in-custody defendants are to appear via video and that attorneys must appear via video as well, and that attorneys must prepare their clients for the hearing prior to the hearing. That might sound odd to some people, but many times criminal defense attorneys are able to speak to their clients during the hearing while the court hears other matters, but because the court moved to alternative means appearance, there will be essentially no attorney-client privilege communication during the hearing, which means attorneys and clients need to discuss prior to the hearing what the client wants to do at the hearing. On March 19, 2020, Administrative Law Order 20-07 regarding probate matters stated that if there must be a hearing, it should be continued 30 days. If there's no objection, then the probate matter will be on the approved list. Matters that will be decided on the pleadings or by hearing by alternative means. Sale confirmations may occur without a public bid unless a notice of overbid is filed and served 72 hours before the date of the sale confirmation hearing. So essentially this just kind of removes the public bidding wars that go on in probate matters, and it's probably just all going to be approved on the paper. Another administrative law order issued on March 19th was Administrative Law Order 20-08. This discussed that pleas are continued for 30 days, adjudicatory trials are continued 30 days, dispositive hearings are continued based upon 30 days or will be decided on the report that's already on file with the court. Termination of parental rights hearings will be continued 30 days, and placement at Child Haven, also known as the local orphanage, is strongly discouraged. On March 20th, Administrative Law Order 20-09 stated that the court is unable to waive the statute of limitations for medical malpractice cases, and that if as an attorney wants a subpoena, that within the next 30 days, the attorney must have permission from the Discovery Commissioner to issue a subpoena, that Nevada Rule of 16.1 Nevada Rule of Civil Procedure 16.1 conferences may move forward but by alternative means, and that depositions and other discovery matters are continued for 30 days. Another order issued on March 20th, 2020 was Administrative Law Order 20-10, that there will be no more in-person filings, that you need to mail those filings in instead, and that there will be no more courtesy copies or no more physical paper courtesy copies, and that there's no longer a need for original signatures except for the few matters that have to be notarized. On March 25th, 2020, the court issued Administrative Law Order 20-11 that stated that confidential reports may be emailed. It suspended courtesy copies, which had already been suspended. And so the early case conferences are to continue, but via alternative means, and the discovery deadlines are stayed for 30 days. Settlement conferences were vacated. Writs of garnishment for child support were allowed to proceed. On March 27th, Administrative Law Order 20-12, this deals with juvenile delinquency matters. In custody matters were to proceed. All others were to be continued or to go forward by alternative means. On April 17th, 2020, Administrative Law Order 20-13 suspended all jury trials, and attorneys were admonished not to take advantage of the pandemic. Grand juries were also suspended, and essential cases such as child custody cases were to move forward, and all non-essential cases were going to be stayed and or told. On April 21st, Administrative Law Order 20-14 was issued, which provided a means for search warrant applications to be issued to judges or provided to judges via electronic means versus having a wet ink signature. On April 28th, 2020, Administrative Law Order 20-15 stated that Department 11 is to receive 50% of the randomly assigned juvenile delinquency cases and only hear matters on Mondays and Wednesdays. Department L will hear matters on Tuesdays and Thursdays. May 21st, 2020, Administrative Law Order 20-16 stated that everyone at the courthouse, including vendors, must wear a face covering, engage in social distancing, and only 4 people are allowed on an elevator at a time. On June 1st, 2020, Administrative Law Order 20-17 was issued. This is the big order that if you have questions about what you need to do, go first to Administrative Law Order 20-17 because it really outlines what is going on in all the departments. Face coverings are required, electronic signatures are accepted, meetings may be telephone, audiovisual, social distancing, tolling deadlines end July 1st. There's a new process for submission of electronic orders, which wasn't really new because if you recall a couple of orders back, we were told about submission of electronic orders. Offers of judgment made from March 13th, 2020 to June 30th, 2020 are valid, meaning you don't have to respond until July 10th, 2020, and stay of cases are going to be on a case-by-case basis, and in-custody appearances will be via video. A lot of the 20-17 Administrative Law Order was implementing in one order a lot of the issues and procedural changes that were in prior orders. And then on July 8th, 2020, Administrative Law Order 20-18, this is the most recent order, states that Las Vegas Convention Center will be used for a trial so that everyone can social distance and participate. So that's the summary of the 18 administrative law orders that have been issued by Clark County District Court since January 1st, 2020 up until July 20th, 2020.